About executive overreach in Ontario, Canada. In this case, involving Tesla Motors suing Ontario Ministry of Transportation. So this lawsuit, known as an application here by Tesla, was to strike down an Ontario government's recent decision to exclude Tesla and its customers from a 2-month extension of government subsidies for electric car buyers who bought cars before July 11, 2018. So the government intended to end this subsidy program anyways in September, but extended it for 2 months. They left Tesla out of that extension, saying it only applied to franchised automobile dealerships and did not apply to Tesla where vehicles are ordered directly from the manufacturer by the consumer. So Tesla submitted this application arguing that the government unlawfully targeted it without any rational basis. And here in Ontario, this application was held and the decision was quashed, set aside. So the issue here, the legal issue, is whether Tesla was unlawfully targeted by the government's recent decision to exclude Tesla and its customers from the 2-month extension of subsidies. And if so, was Tesla targeted without any rational basis? So some of the legal rules that apply here and that were used in the analysis of this case: the government has the right to order its priorities and direct its fiscal resources toward those initiatives or programs that are most compatible with policy. That's from the Hamilton-Wentworth case. And it's not for any court to oversee a minister of the Crown in policy decisions or in the exercise of their discretion while spending funds entrusted to their department by the legislature. And that's from the INRI Metropolitan General Hospital case. One distinction, though, from that INRI Metropolitan General Hospital case, and that was restated in this case, just as it's not for the court to tell the government that it must fund a highway or it must spend funds on this or that project, it is very much the role of the court to inquire into the propriety or the lawfulness of a payment or withholding of a payment under statutory or regulatory laws. So, in judicial review, the reviewing courts are in the business of enforcing the rule of law, one aspect of which is executive accountability to legal authority and protecting individuals from arbitrary executive action. That's from the Reference Secession of Quebec from 1998. Also, the exercise of the prerogative will be justiciable or amendable to the judicial process if its subject matter affects the rights or legitimate expectations of an individual. That's from the Reference Canada Assistant Plan. Basically authorizing courts to step in when the executive is doing something that affects the rights or legitimate expectations of an individual. So here's some of the analysis that comes from the judge in this case. So he's saying that the cabinet, in its attempt to cut Tesla out here of the 2 months, they decided to cancel cap and trade and to stop funding projects paid from cap and trade tax revenues. Those are policy decisions. The court's not going to interfere here. They say it's not their place. Number two, the government decided to continue to fund the electric car subsidy program for another 2 months. And this funding was established under environmental legislation related to the promotion of clean energy electric motor vehicles. So the decision to continue to fund the program for 2 months, also not the court's territory. This is a political or policy decision. But in number three, the government established the terms and conditions of the electric vehicle subsidy transition. So they looked at it under the environmental regime and under the power to set terms, and they designed those program terms so as to only include franchised dealers and to exclude Tesla specifically, pretty much, or it acted in that effect. So in setting the operative terms of the transition program, the government went from policy setting to executive program administration. So it's whether that decision was legal under the Public Transportation and Highway Improvement Act and the laws that surround it, that's what the court is digging into here. And they don't think so. They're saying whether this goal was wise or not, that's not their concern. That's policy, that's politics, that is not the realm of the court. But the means by which it's implemented by the exercise of statutory and regulatory decision was arbitrary. It was unrelated to the achievement of the supposed policy goal. It was also not related to the conservationist purposes of the electric car subsidy program. It was also not related to any purpose under the Public Transportation and Highway Improvement Act. So this Ontario court said no way. Furthermore, the government was ordered to reimburse Tesla for the cost of $125,000 for their court cost. And thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.